And now I will announce panel 1, the evaluation of 20 years of the ICTY. Our panelists are, once again, Judge Theodor Meron, the president of ICTY, Medrida Creso, the president of Court of BIH, Catherine Bomberger, director general of ICMP, Professor Robert Cryer, Birmingham Law School, and Natasha Kandic, project at ECOM. The moderator of this panel will be Anisa Suciska-Vekic, country director of BIN, BA. Hello to everyone once again, ladies and gentlemen, your excellencies. I wish to introduce to you members of the panel where we will discuss the assessing of the 20 years of the ICTY. We will provide you with an overview of the situation and the debate on the legacy of the tribunal. We will have the representatives of once again, I will introduce Judge Theodor Meron, the president of ICTY, Mrs. Medrida Creso, the president of the Court of BIH, Ms. Catherine Bomberger, Director General of International Commission on Missing Persons, Professor Robert Cryer of the Birmingham Law School, and Mrs. Natasha Kandic of the project RECOM on Fund for Humanitarian Right from Serbia. We have already heard Judge Meron, who spoke already of the importance of ICTY for former Yugoslavia, the accomplishments of the tribunal, which were numerous, of course, starting from starting from the precedents in international criminal law, influence on development of local criminal justice, processing of war crimes, and so on. However, there were numerous criticisms for the tribunal coming from the address of those that the tribunal was working for, which is the victims and the public. Now I will give the floor to President Meron to address us once again and perhaps add some more details on what he already spoke of. What is the assessment of the tribunal after 20 years of its work? The floor is yours, President.
Thank you very much, Madam Moderator. I spoke at some length, and I think we would use our time much more effectively if I were to waive my time and give it to my distinguished colleagues, the panelists. But let me add one word to the lengthy speech which I gave earlier. I think that I can be enormously proud of the achievements we have made. We have started from the scratch after half a century of impunity since Nuremberg. We had to start from having the first set of rules of procedure of evidence because we did not have anything. We did not have computers, we did not have defendants, we did not have staff, and we started from having even a part-time prosecutor. And because of the credibility that we have established in our work and the growing support of governments, eventually we arrived at this incredible record of having 100% record of arrests. Very few countries would be able to achieve this record, and I'm sure that in this respect, we are the envy of very many police and judicial institutions in the world. But we have also shown that we can try case after case, applying the entire panoply of due process and human rights, and that we only convict when there is enough evidence to convict somebody beyond reasonable doubt. Our work is still a work in progress, and I suggest to all of you to wait until we have completed our work to judge it holistically. And I'm quite sure that one day you will join me in a feeling of very strong pride about the work of the tribunal. So here I will end with that and yield the floor to my distinguished co-panelists.
Thank you, Judge Meron. The legacy of the tribunal was mostly seen in development of the judiciary in Bosnia and Herzegovina. The court of Bosnia and Herzegovina was the first one to start processing of the war crimes, the most severe crimes that were committed on the territory of Bosnia and Herzegovina. And it is probably the court that has, in the 7 years since its existence, has created some of the biggest achievements in such processing of the cases, where over 250 indicted persons were convicted for war crimes committed on the territory of Bosnia and Herzegovina. The Court of Bosnia and Herzegovina has been a pioneer in the region, and it's still a pioneer when it comes to the court practice in this region. However, in the last several years, the legacy of the tribunal, meaning the transfer, the transition of good practices, was reduced in sense of the public perspective, public perception, because of the latest actions of the tribunal, particularly the releases that recently happened, where the persons previously convicted for genocide were released. The president of the Court of Bosnia and Herzegovina, Medžida Kreso, will tell us a bit more about the legacy, the practical examples of the legacy of ICTY in the work of the Court of Bosnia and Herzegovina. Dear Mr. Meron, ladies and gentlemen, dear guests, it is my pleasure to attend this conference today and to share with you my views on the importance and the role of the International Criminal Tribunal for former Yugoslavia regarding the building of the legal framework and practice of the courts in Bosnia and Herzegovina regarding the processing of the war crime cases. I will try to be brief and speak of the perspective of the Court of Bosnia and Herzegovina and the basic elements of the legacy of ICTY. First of all, I would like to emphasize the specific position of the Court of Bosnia and Herzegovina regarding this issue, namely Resolution 1503 of the UN Security Council of the 28th August 2003 establishes that one of the key preconditions for implementation of the strategy of the finalization of work of ICTY is the establishment of a special department for war crimes within the Court of Bosnia and Herzegovina, and later on transferring of certain cases based on the Rule 11 bis to this particular department. In that sense, it is very important to see the contribution of ICTY to establishment of this department and creating conditions for its efficient work. Keeping in mind a very significant role, which in line with the resolution of the Security Council was had by ICTY and the OHR in creating conditions for work of the War Crimes Department of the BH Court, I'm particularly glad to be able to look back at the time before the establishment of this department in the presence of Mr. Meron, who at that point was also the president of ICTY. After adopting this resolution, we've had a very active period of promotion of the legal framework on the level of Bosnia and Herzegovina with the goal to establish an efficient department for war crimes at the court of BIH, where it was really important to work based on the rules of procedures, organization of work, and good practices of ICTY. I would also like to emphasize the importance of the legal solutions in the area of international humanitarian law, which were taken over or created under the influence of the statute and the Book of Rules on Proceedings and Evidence of ICTY, but also the relevant international conventions. By a new criminal law in Bosnia and Herzegovina from 2003, this new law actually included for the first time the new crimes that were not explicitly defined by previous laws. Primarily, by this I mean the crime against humanity. Also significant, of huge significance, were the legal solutions related to protection of witnesses, which were also created based on the rules and practices of ICTY. So based on the ICTY solutions, we have established a legal framework defining the topic, defining the area of witness protection, and also definition and implementation of measures of witness protection, protection of witnesses that are under threat, as well as endangered or witnesses that feel they are in danger. So now, in proceedings at the Court of Bosnia and Herzegovina, when dealing with those categories of witnesses, we can set different measures of protection, making it possible for them to give their statements with less fear, or ideally without fear, for their own safety and safety of their families. Additionally, on level of Bosnia and Herzegovina, we have adopted and we are now implementing a special law defining the responsibility of the State Investigations and Protection Agency regarding the establishment and implementation of the Witness Protection Program. Another important aspect of the legacy of ICTY is the court practice. Detailed analysis and theoretical considerations of the status of certain crimes according to the international humanitarian law, defining important elements of specific acts that were committed, as well as the standards that ICTY has set regarding the proving of those actions, are some of the most important sources that the Court of Bosnia and Herzegovina uses during the trials. Following the practices of ICTY, the Court of Bosnia and Herzegovina has also started implementing the concept of joint criminal endeavor, which is also a form of criminal responsibility, which is an absolute novelty in criminal legislation of Bosnia and Herzegovina. To this, we also have to add the practice of ICTY regarding the command responsibility, especially when it comes to the standards of the jure and de facto command, or the factors that have to be taken into account when evaluating the existence or non-existence of this type of responsibility. Further on, another important element of legacy of ICTY is definitely the institute of the use of evidence collected by ICTY and acceptance of facts and evidence established in the verdicts of the ICTY. The war crime cases, in different wartime cases, to prove different elements of crimes, for example, armed conflict, wide and systematic attack at a certain area, and so on. It is necessary to share hundreds of material and other types of evidence to prove a single fact, which is a general element of a crime. On the other hand, in front of the same court, we have large number of crimes committed in identical context and circumstances of conflict at the given area, trying to establish more efficiency in criminal proceedings and war crime cases, and in order to prevent readdressing the same witnesses and further traumatization of those same witnesses, we have adopted the law on transfer of cases by ICTY to the Office of the Prosecutor of Bosnia and Herzegovina, and the use of evidence collected by ICTY in proceedings at the Court of Bosnia and Herzegovina. Through this law, we have established a special regime of the use of evidence collected by ICTY. This completely new concept was not accepted with understanding in domestic expert circles. However, we can say that today this institute is alive at the Court of Bosnia and Herzegovina, and it is being more and more used by the defense.
All the foregoing institutes and measures followed from the legal framework and jurisprudence established through the proceedings before the ICTY. They are a novelty in legislation and jurisprudence of BH judiciary, and they are of extreme importance because through them and a framework was created for efficient processing of war crimes before national courts. It is a basis and primarily before the Court of Bosnia and Herzegovina, which uses it a lot. However, these novelties created a basis for transfer of cases from the ICTY to BH judiciary, enabling the judges of Bosnia and Herzegovina court to complete all the cases transferred by the ICTY within a very short period of time, following the rule 11 bis. I believe that I can say it with certainty that the Court of Bosnia and Herzegovina in the past, over the past period of time, that the cases of war crimes tried before national jurisprudences with all due respect to international standards, not only possible, but in many cases more efficient and cheaper than other trials before some other international courts. Of course, I have to note here that all of this would not have been able to achieve without tremendous support of the ICTY together with other relevant organizations, including OHR, OSCE, and Council of Europe. I hope that the Court of Bosnia and Herzegovina and Department for War Crimes would continue to receive this support in our difficult work in the future. This would end my brief introductory remarks, and during the discussion we will have an opportunity to go into details about the elements that I have just mentioned. Thank you for your attention. Thank you, President Kreso. So Bosnia and Herzegovina is a country which had a huge number of casualties that are registered as missing person. It is unique that more than 70% of persons that were registered as missing during the war. So this success is due to the cooperation of forensic experts of the missing persons and the prosecutor's office during the proceedings that were conducted before national courts. I would kindly ask Mrs. Catherine Bomberger, Director General of the International Committee for Missing Persons, to tell us in what way do you assess the work of the tribunal in the last 20 years and how much did it affect missing persons in the territory of Bosnia and Herzegovina be found.
Thank you very much, Anissa. It's an honor to be here, and a great honor and privilege to finally meet President Meron. And thank you, ladies and gentlemen. I think today's discussion will focus a lot on the verdicts obtained by ICTY, which many consider to be controversial. But I'd like to remind everyone that there's a longer process involved in the process of obtaining justice. And part of that process, as Anissa noted, is obtaining evidence for criminal prosecution purposes. And this is a long, long process, and it's been an extremely long process, not only for ICTY, but for the countries in this region. Obtaining evidence is, I think, something that is brand new in the context of peacetime and following conflict with countries in this region. And I think the legacy of ICTY in the context of obtaining evidence is very new, I have to say, and what happened with ICTY is unprecedented. I don't know of any other situation in the world where armies of archaeologists, anthropologists went out to mass grave sites, clandestine grave sites, following the end of hostilities to collect evidence of crimes, of war crimes, etc. And in the process of doing so, they also collected evidence of not only war crimes, but also skeletal remains of those who went missing. So I would say in the context of missing persons, to address Anissa's question, something unusual has happened, and I hope we don't go back in time and reverse what has happened in the context of the former Yugoslavia. Through the efforts of ICTY, now over 3,000 mass grave sites or clandestine grave sites have been excavated. This has not been done exclusively by ICTY. Thankfully, all of the governments in this region, as Mercedes Creso noted, all of the governments in this region, through their war crimes prosecutors' offices, whether it's in Serbia, Croatia, Bosnia-Herzegovina, and in Kosovo, under the auspices of EU-LEX, have excavated a large number of mass grave sites. How this evidence is used later on we can talk about, but this is brand new, and I think this is something we really have to analyze in terms of not only the legacy of ICTY, but what it's going to mean now to future conflicts as we look forward to Syria. How is this going to happen? How do you set up the mechanisms on an international level and a domestic level to be able to investigate such massive crimes? And this is very, very difficult. And as Anissa noted, in the context of the Western Balkans, over 40,000 persons went missing as a consequence of gross violations of human rights, war crimes, and other atrocities. Today, 70% of those who have gone missing have been accounted for. But this was not foreseen when ICTY was originally created. And their mandate was to go out and collect evidence for the purpose of criminal prosecutions, and part of that process was finding mortal remains, looking at ligatures, looking at bullet wounds, looking at evidence of crimes that were committed, but no provisions were made at that time, and it was impossible, if we turn back the clock, to actually identify those individuals that were being found. As a consequence, large numbers of mortal remains were handed over to local authorities, leaving it to them to identify these victims, and many of the families of the missing and others who participated in that process are here today, and they know how agonizing that was in the beginning, because they saw the mortal remains of their relatives being exhumed, they saw a process of justice beginning, which held out hope for them, but there were no means to identify the victims. Simultaneous with the efforts of ICTY, and I would say the local governments here, there was a progress in the use of forensic sciences, which augmented the ability to provide accurate information based on evidence that was being collected. A new science came on the table, DNA technology, and the use of DNA in human identification cases. This allowed the large-scale identification of those remains that were now being exhumed by ICTY and other authorities, and allowed for the first time a large-scale process of identifications upon which most of the identifications in the former Yugoslavia are now based. But this has been a long, long process. So excavating mass grave sites, ensuring that ICTY was there, and later on handing over that process to local authorities and making sure that the prosecutors, war crimes prosecutors, were in charge of excavating mass grave sites, brought in something new. So what we're moving from in the 1990s is a process of a humanitarian process of tracing missing persons to a law-based process of investigating disappearances that are connected possibly with war crimes. And that is a fundamental shift that I think we have to analyze and we have to take note of and we have to make sure continues. We can't pull back the clock. The families of the missing not only want to know the identity of a missing loved one, they want justice. So as we move forward now with how you collect information, how you conduct investigations, how you collect evidence, I think we have to note what has happened here because there have been many, many problems. It wasn't a perfect process. But as we look at the legacy and we look at other conflict zones that are occurring or other places where this type of investigation can be applied, we have to take some of the lessons learned from the process here that was started by ICTY and the governments in this region and see how we can apply it. But I think the primary legacy or lesson I would say we've learned is that searching for missing persons needs to be based upon a rule of law-based process. And ICTY has changed that, has in an unprecedented way, I think has led to a process where families of the missing can hopefully have justice based on the accurate collection of information from mass grave sites, retention of that information, proper documentation for use in court purposes. Secondly, the use of modern forensic methods in the process of investigation, which allows for accurate identification in an accurate process, and being able to provide that evidence for court purposes for families of the missing is absolutely critical. Third, the engagement of families of the missing, and I think that's what's important here today as we analyze the legacy. The families of the missing have been very much involved in this process from the beginning, And I think there's been a very good outreach program, and also the governments in this region have created an environment, I think, of protection where there hasn't been a fear of reprisals for families of the missing to become powerfully engaged in this process. So I think these are some of the legacies that I would analyze in terms of the investigation of missing persons cases linked to criminal activity that are an important legacy left behind by ICTY, and one that can now be analyzed or applied possibly to other conflict zones.
Hvala, Catherine.
Over the past 20 years of its work, the ICTY has managed to collect a huge archive pertaining to former conflicts in former Yugoslavia by making a decision to establish residual mechanism. ICTY decided to keep this archive in The Hague. Those states who decided to open information centers would enable the access through electronically to this archive. It is the hugest significance would be by local authorities. The professor Robert Cryer from Birmingham Law School would tell us how important is the use of archive and archive per se for legal community. But Professor, I would kindly ask you to open some other issues that would be dealt by academia when speaking in connection with the legacy and of the work of the ICTY for future generations.
Well, thank you very much, and thank you very much for having me here. As you've mentioned, I can only really speak from an academic perspective because that's all that I really know about. In many ways, the history of modern international criminal law is coterminous with the history of the ICTY. And in many ways, the legacy of the ICTY, for me, is international criminal justice. I remember when I started to look at international criminal law in the early to the mid-1990s, and in truth, there wasn't really an academic discipline of international criminal law really worth a huge amount of study. There were some scholars who were working in the area. Professor Meron had begun working in the area just around that time, and there had been people who'd been around, such as Sharif Bassiouni, who'd looked at international criminal law to some extent. But there was very little advanced communities of international criminal lawyers. And that all changed with the coming into being of the International Criminal Tribunal for Yugoslavia. And in many ways, in fact, what we can say is that the legacy of the International Criminal Tribunal for former Yugoslavia began at least in 1994. And that was with the creation of the Rwanda Tribunal. In 1994, the new Rwandan government came to the United Nations and expressly said, why is it that we do not have a tribunal? Is it because we're African? Had the ICTY not been created, it seems very, very unlikely to me that there would have been an International Criminal Tribunal for Rwanda. Furthermore, there would not have been a special court for Sierra Leone. And perhaps, I think as Professor Meron has already said, there probably wouldn't have been an International Criminal Court. For the most part of this past 20 years, it has to be said, the centre of attention of international criminal justice has been the Yugoslavia Tribunal, in many ways because of the various firsts which it represented. It was the first international criminal tribunal post-Nuremberg. And then early on in its practice, there was the groundbreaking decision of Prosecutor versus Tadic, which very much set the agenda for international criminal law for a very long time. And indeed, a great deal of academic ink has been spilt simply on that case alone. And since then, the decisions of the tribunal have been subject to huge academic scrutiny, both positive and sometimes not as positive. But each and every time, the ICTY, in my view, has set the agenda for what is discussed in international criminal law. And that came through, I think, particularly in the Rome negotiations. I was a very, very junior semi-official member of the British delegation to the Rome conference that set up the International Criminal Court. As a friend of mine was working for it, and I was allowed to go along on one condition, and that condition was that I did not open my mouth. I did not do so, and I listened. And what I heard was whenever something was going to be discussed, we would hear, Tadic says this, Tadic says that. And that was an important argument that was brought into being. And indeed, without Tadic, I think it's almost certain that the Rome Statute would not have had jurisdiction over war crimes in non-international armed conflicts. Furthermore, though, the practice of the ICTY on various different things, we've already mentioned victims, we've already mentioned witnesses, even where it wasn't adopted in the Rome Statute on the rules of procedure and evidence, was framed the debate as to whether people, or what needed to be done. And what was often thought of as an abstract exercise of trying to create procedures actually was made concrete by the practice of the tribunal. And indeed, the practice of the tribunal has been vastly influential in various other courts. Decisions of the Yugoslavia Tribunal have been very, very influential, as we've already heard, in the Bosnian courts. Similarly, in the United Kingdom, when dealing with international crimes, the UK courts are suggested to take into account decisions of international criminal tribunals by statute. Furthermore, the Bangladesh Tribunal, for example, has made extensive use of ICTY jurisprudence. But so has the Rwanda Tribunal, the Special Court for Sierra Leone, the International Criminal Court as well. And so its practice has been vastly, vastly influential. But also, from an academic point of view, it forms an absolute centerpiece of teaching people about international criminal law. And so the cases of the Yugoslavia Tribunal remain on the agenda all the time where international criminal law is taught. And as such, that form of teaching in and of itself passes on the facts and the law that the Yugoslavia Tribunal has established to new generations. And I think that's hugely important. If we think back to 1993, the Stockholm International Peace Research Institute estimated that there were at least 13 conflicts ongoing during 1993, with over 1,000 deaths. Conflicts like those in Burundi and that in Angola, which are not really spoken about in the same way now as Yugoslavia. Why? Because there wasn't a tribunal. There wasn't something which was set up. There wasn't something which established the facts and established the law in the way the Yugoslavia Tribunal did. And so in and of itself, I do believe that the teaching of international criminal law can involve a form of memorialization of the victims insofar as their stories get told and passed on to future generations. On top of that, the archive of the tribunal, which I think is a hugely important resource, will be looked at for decades by scholars, by lawyers, by anthropologists, by historians, and written about. And to finish off, I just simply want to say that which is written about is not forgotten. Thank you.
Hvala, profesor Mayer.
Thank you, Professor. During the trials, during the war crime trials, what comes out in the end is the court truth. We are witnesses of truth having multiple faces, but the truth is the truth. However, more and more is being said about the power that alternative mechanisms could have on the territory of former Yugoslavia to provide for reconciliation, improvement of relations between different groups. If we were able to find and write down all those stories that were never heard in different courts, also to provide for alternative mechanisms to ensure compensation and to implement all the 4 pillars of transitional justice. Natasha Kandic, a woman that for the last 20 years, over 20 years, has been working in the area of transitional justice and ensuring rights for the victims on the territory of former Yugoslavia, will tell us a bit more about Erekon, an initiative to help bridge all the gaps that remain after the process that the judiciary in the countries of former Yugoslavia has been leading and is still a part of. A small correction. I will stick to the topic, the assessment of 20 years of ICTY, and then in the context of that main topic, at the end, I will say a few words about RECOM. For some of you, perhaps RECOM is not something that they are familiar with, so I will say a few words. So, marking of the 20 years of work of ICTY is a good occasion to talk from different angles about the work of the tribunal. My angle is based on 20 years of research regarding documentation of war crimes, also in support to establishment of criminal justice, and also overviewing the gaps that exist in the systems and thinking of mechanisms that could potentially make for a more comprehensive overall picture of what actually happened, why it happened, why the war crimes happened in the wars that took place on the territory of the former Yugoslavian countries. I selected several categories that I will focus on, several issues that I will say a few words about, because I think it could be an inspiration for you to discuss them later on. What is the very thing that we can say 20 years later? What was the success of ICTY? I believe I had a privilege to be the first one from the NGO community to be invited by the ICTY prosecutors to help them in collecting and documenting the evidence and witnesses regarding the war crimes that were committed on this territory. I remember those early beginnings because I followed it all closely. I followed closely the work of ICTY, and starting from this enormous support in documentation, in providing witnesses, from all that, in the end, I have to say I feel sad. I feel quite disappointed by the current results of the work of ICTY. At the same time, not everything is black and white. I still have hope that things can be corrected in the times that are ahead of us. So, what, in my opinion, is the success of ICTY? To put it simply, it cannot be denied. The biggest value of ICTY is that it finally stopped the practice of not punishing the perpetrators, not punishing the high-profile perpetrators, leaders of the military, civil authorities, police in the countries of former Yugoslavia. During the war, in the countries that were only at that point gaining their independence. No one was to expect that some of the prominent creators of the peace agreements at that point, and those who signed the peace agreements at that time, who led their nations, their countries at that time, were going to find themselves in front of the ICTY. That is how a signal was given that no one was going to be left aside. And this is something that actually did take place. We do have the persons that are indicted and that are convicted, high-profile persons or previously high-profile persons who were found responsible for what they did. However, we have expected that a Hague Tribunal, in preventing this practice of non-punishing the perpetrators, we hope that ICTY was going to be able to prevent mass crimes. Unfortunately, we have the example of Srebrenica, and this is something we have to think of. We have to think that ICTY or any other court still does not have an appropriate strategy to prevent what happens in such cases of mass crimes. So this is something that remains to be analyzed by the legal experts and strategists, trying to find an answer to that question. How to deal with this issue in the future, how to prevent another Srebrenica happen anywhere in the world in the future. Some of the best things about the ICTY is its legacy, related particularly to specific events, specific war crimes, specific individuals that committed certain war crimes. And the part that sheds light on responsibility of those who were indicted and convicted for specific crimes. This, in my opinion, is something that we can have the most use of in all the countries of former Yugoslavia, to create firm guarantees that something like this will never happen again, that the politicians will never be in a position again where they can create wars, where 100, 130, and even more than that, thousands of people. So this legacy is important. Also, if we take into account the fact that large number of documents are not public, a lot of materials are not public, that the countries have used their right of veto in publishing or disclosing some of those documents. If ICTY did not exist, we would not even have 100th part of what we learned from those documents, because we would never have the access to such materials, and we would have been deprived of our own autonomous thoughts on what actually happened based on the facts that we were able to learn of. Future generations would never know what happened. They would stay in the dark. They would never be aware of any of those things. So this is all a fact, despite the number of the documents that are closed, that were changed. Still, there is a value in all this. We have to overcome what happened to us in the past. At the same time, we need to keep in mind that it is now the last time, the last moment, for us to realize what are those mechanisms that we need to overcome the limitations or the restrictions of criminal justice that exist, and to provide for the new mechanism to function. Whether ICTY was successful in providing for objective and impartial trials in the countries of former Yugoslavia, it's an important question. I don't think ICTY was not successful in this. And let me give you an example. In Serbia, before the change of authorities, there was no single trial on war crimes. There were actually several attempts that were so weak, so shameful, that they have to be mentioned for that sole purpose. In Croatia, there were trials to others, because it was considered that in Croatia everyone was a victim, that no one perpetrated a war crime. So ICTY during those 12, 13 or 40 years was not successful in enabling national prosecutors' offices on understanding the meaning of criminal justice, the post-war transitional justice, the rule of law, to understand what happens if the crimes that were committed were not punished, and so on. However, it still happened that war crime trials at domestic courts have becoming more and more frequent, that there is more and more objectivity as the time has been passing. Of course, no one is satisfied, and no one can be satisfied, because there are no courts with the capacity to indict everyone who committed a war crime. And that is also something that we have to come to terms with. However, it is good that such trials exist. They do exist, despite all the deficiencies, all the restrictions, all the partiality. Those trials are still very important, and it's important that they exist, that they happen, even in the cases when they are focused on direct perpetrators, on individuals that were engaged by the countries from criminal milieu. Even in such cases, those trials are very significant, because families of the victims can say, for example, in Kosovo now, they can say, we know it was not Milosevic in person coming and killing someone in our village. We know that someone was sent by someone else, and those are the people we saw. And we want to see justice for us. We want those direct perpetrators punished for what they did. So we can be pleased with that improvement regarding the processing, domestic processing of the war crimes. The problem is, and this is the most inconvenient thing, so I'm really glad that Judge Meron is here with us, because this has to do with him as well. In the last years, what has been happening are the trials resulting in perpetrators being released, including the cases of command, responsibility, and joint criminal endeavor. And this is not something that NGO activists have been more and more focusing on. Everyone who has been following and supporting the work of ICTY for the last 2 decades, supporting the need that ICTY exists and that ICTY acts the way it has been acting. There is now a serious expert discussion in legal community, which is something that has to be taken into account at this particular point, but also in the future, once ICTY in a different shape continues its work through the residue mechanism. Those verdicts are a large danger for us. A judge, not for judges of ICTY, but danger for us, because that introduces us to this new state, to this new situation, which is a complete confusion regarding the standards that have been established in the last 17 or 18 years. Suddenly, there are new legal standards leading or bringing into question the facts related to responsibility of the states. Let me try to simplify this. We all are aware that some of the crimes do lead to shedding of more light to something that we know as responsibility of the states. For example, the trials to the generals, command responsibility, joint criminal endeavor, and everything else relevant in this regard, provided enough insight or certain amount of insight into the responsibility of the states, even though we know, of course, that ICTY only deals with individual criminal responsibility. It does not try the states, nations, or society. Suddenly, however, we have those new standards where this whole war, this whole horrible past that we have, is slowly being reduced to individual perpetrators. When we look at them, when we look at their biographies, their past, we see that most of them come from a single criminal social milieu. There are judges of ICTY who explain those new standards as the situation where instead of legal reasons or legal reasoning, now we have political reasoning. And this is not just a phrase. The explanations of those verdicts are followed by short explanations. These explanations are very short on what actually was the decision-making factor in deciding to release someone. Those political reasons I referred to a bit earlier, that everyone that many people now keep referring to lead to different countries who have now their armed forces on the territory of other countries at this point. I will not go into details of this. Perhaps this is a topic for a different discussion. But let me just tell you that that particular issue has caused serious disappointment in all those who have been using their research capacity for years to support the work of ICTY, who have been trying to lobby for ICTY, to assist ICTY in their work. One more thing about certain unrealistic expectations that we all had, including myself. Whenever someone mentions ICTY, even the judges or prosecutors of ICTY, what always comes up is the word victim and the word reconciliation. However, we all know that ICTY has a single task, which is assessing the evidence and establishing criminal responsibility of those indicted. ICTY cannot evaluate the level of suffering of a victim. It's not its job, it's not its task. And the same goes for reconciliation. ICTY establishes facts, and we should then use those facts established by ICTY to try to create something that overcomes criminal justice, that goes beyond criminal justice, that has to do with our past as well as our future, and the future of the generations to come. Reconciliation is a really serious process. It is not a task of ICTY, and this is something that everyone has to understand.